and also talk about minorities. The second one is freedom of speech. Third topic, freedom of religion. Fourth one, rights of arrested and accused. Fifth one, death penalty. The sixth one is privacy, including sexual orientation. The sexual orientation is basically we are talking about the gay rights, etc. Section 377 of the Indian Penal Code for the Indians. I think US will know.
Could you explain how that ties into privacy? Just like what you do in privacy? I mean, in privacy.
Yeah, what covers under privacy in US?
So
I think you could bring in your abortion laws, abortion, contraception, sexual orientation, right to privacy. Because there is a whole lot of other rights, but because yesterday when you are talking about human rights issues, most of them that popped up is based on this. That's why we thought the students are more interested in learning on this, so we put up this studies. How are we making the groups?
There's 6 groups, and there are 30 of you?
No, we had 14 internationals.
No, not 30.
14. Including here.
Okay, so US students, raise your hands. 1, 2, you're with Indian students. 1, 2, 3, 4, 5, 6. 1, 2, 3, 4, 5. Did I get you?
Anna is 6.
I got you?
Yeah.
Okay, Anna 6. John is 1. Okay, those are the 6 groups. And Indian students, raise your hands. 1, 2, 3, 4, 5, 6. 1, 2, 3, 4, 5.
Yeah.
Him 6. 1, 2.
Okay.
Wait, you're under Indian?
You remember your numbers now?
Sometimes I'm US, sometimes I'm
Ones, get together over here and go where you want to. 2, 3,
No, I know what I said about another
4, 6. Meet in your groups and then you can go. Yeah.
Yeah, you don't get any.
Or maybe it's not.
It was public authority is there. Like for
Maybe right to be represented.
right to be
Explicitly stated.
No, we have right to be represented.
No, but for the certain
powers of like the basic structure of unification, like the fundamental.
So can never be changed. So is it the death penalty? Could that be changed? No, why not? Because that's a fundamental right.
No, not a fundamental. It's like it is not a fundamental, but it is like article programs are and the budgets one is that Article 14, Article 4 is for equality. Article 21, it is for right to life. That is when there is a procedure established that is directly elected manager then once on the basis of state level So this is also that trinity is not aggressive.
So how do you establish a valid base? How do you establish what is valid?
That way, there are certain moments of the
According to
due process says
States in India, states primarily agricultural states. So all the people, like no matter if you're of any caste, everyone in that state, if you're a citizen, like if you have a resident from that state, you're a member of the other one, like you can claim a right. So it varies from that. Because Haryana is in India, Haryana is an agricultural place, right? So mostly all the whatever. But again, it depends. If you want to get an admission in a college or whatever, then you can't get it just because you're from Haryana and you're called Afghan class and so you show that you have and you're not more than 55.
The whole idea is that you have
If you don't have right to work, if you don't have right to sustain yourself, you don't have shelter, you don't have food to eat, that means your right to life is restricted. Right to life means right to the dignity. So if you want to get where anyone exists, just freedom of speech, expression, things like obscenity, you have obscenity, that is part of your life. That's where the restrictions comes in. Because in fundamental rights, no right is absolute. So if saying that the state can impose harm, therefore all times to come, exactly, absolute. Because in the United States, on television, states are during daytime hours when there are children, but at nighttime, people pay television channels. If they can have any kind of language and show any kind of action, that would not be for all times, no demarcation in the night or in the day. You don't have to show that. You don't have to show that. And job seat or that will not go during.
I used to think it now, the television,
one exception, the court established this as a law. So this has to be followed by the judge. Basically, because of the right to education and the right to practice, both these factors contribute to privacy. This is kind of the court bottom one side. I'm not sure if I know.
Zooming the kit of focus में आ रहा है.
In India, this is largely similar, but in India, public order is we maintain public order. This is What do you mean create a right to fair people that is going against public orders, courts won't say that. The courts will find morality in public orders.
If you're an unmarried couple, it doesn't matter. You don't have to be married.
And so the Supreme Court said that that law that allowed the doctor to be arrested for giving out contraceptives was unconstitutional because people have the right to decide whether or not to bear or get a child. The law said something like, the doctor was giving out contraceptives and then he was arrested. Because I think,
But they outlawed it.
I think that well, because I think that the people he was giving the contraceptives to were
Doing it anyway.
that's what I was trying to say, yeah.
Absolutely.
Yeah,
Absolutely. But they have, once again, two consenting adults can do anything in the privacy of their home. They can also be allowed to use contraceptives. And there's another case, I don't remember the name of it, you might.
The law that sanctioned for the police to arrest
Right,
for that.
that is outlawed. So that is also falls under privacy. And there's another case, it's not that important, I think, I don't remember the name, but it allows you to sell, I think, like, I guess like, certain kind of, like, I don't know how to explain.
Penalizes some offences if a person loses any right to forceful section 313
mentioning the grounds under the Medical Termination of Pregnancy Act, then it becomes illegal for you to have it, and it's criminal in nature.
Okay, so the female has to have a certain ground, right?
That you can terminate a pregnancy. So you cannot just say that, I was still working, so I want to terminate a pregnancy.
And also, does the female have to have that? Oh, thank you. We used to have where the female would, if the husband was available and if she was able to contact him, if she knew who the father was.
That's not a case.
I think it was like
That's never been happened.
So, even if it's a family I'll just say them yeah.
There was a case about right to privacy. Sarika versus after marriage, she was gone into police for accident. She's not coming to the but after that, Supreme Court had that right to privacy means one can be happy with somewhere else, not with the husband. But it's a wrong issue. After that, they came to know that after having a marriage.
But they can't see it. It is something. We want you to be in line like this.
Alright, speaking of equality, we had trouble defining affirmative action. I mean, there is a definition right there, but like we just talk about it and we assume like that we know what it means. So we had a hard time like articulating it. But what did we decide that was? Like, it was a plus factor to benefit those who were disadvantaged historically. Like,
yeah, I mean, we kind of struggled. Like, how do you? I mean, it's something that's so commonly talked about.
Yeah,
but
affirmative action.
Affirmative action, but like quota versus point system and how it actually applies in the law. Mm-hmm. That's where we actually.
And I thought it was interesting because in the Indian Constitution, you guys like. Oh yeah, sorry. Like you guys. Like, I don't know. Like it's a reservation for them, but it was for us. It's like one factor that gives them a little boost.
why we need to protect those.
Sunny, I'm having trouble hearing you.
Oh, sorry. Why we need to protect those minority groups, and we said, like, for us, it's a classification. Like, it's any gender. Like, you can't discriminate based on gender, race, like those classes. But we're there was a difference there. So
what is it? So in the Indian system, are there similar classes or no?
they specifically name which caste.
Okay, I think I'll elaborate on what the concept of equality and minority exists in India. Like, first of all, our constitution itself gives protection, gives this right to equality to each and every human being, despite the fact whether you are a citizen or not. And then secondly, in the part of fundamental rights itself, we have certain provisions which protect the rights of the certain minority groups, that is like on the basis of race, you can say. They are the scheduled caste and the scheduled tribe people, and also certain other OBC, the other backward classes, which have been recognized by the Supreme Court, and they are given reservation in various governmental institutions on the basis after fulfilling certain criteria which have been defined, and they are given a reservation in the educational institution as well as when they want to get employment in the government sector. And then we also talked about like what exactly minority groups are in India, because the concept of minority rights is not just limited to these three categories of people. We also talk about minority in terms of religion, minority on the basis of like, or disabled people are also regarded as minority in some constitution or in the US legal system, about the minority rights or something like protection. But in India, due to the existing caste system, they were a class of people who were deprived heavily of every kind of facility. Because of that, they have been given specific protection in the constitution also, and there are various other laws that have been made to govern each and every aspect of the lives of such people, so that they are not further deprived or discriminated in any context.
But in the US, like, if I were to discriminate John because he is white, like if, let's say I'm an employer and I said I don't hire white people, then that's still, even though he's technically not a minority, I'm using classification, that race classification, so that would be prohibited.
And moreover, there is a better enforcement mechanism of this right in India, because fundamental rights are enforceable in India, and such right, if we talk about affirmative action, it is not as enforceable as compared to the minority rights in India, isn't it? Yeah.
Thank you.
Yeah, that's it. Thank you.
Speech. Freedom of speech.
Sir, can I add about minority rights? Just not in that group. Firstly, in India, in Article 29 and 30, they clearly define about minorities. But the best part of it, Indian Constitution still doesn't define minority. There is no word as minority in Indian Constitution. It is based on religion and language. That implies minority. That is one. Second issue, in India, we have got 8 major religions, in which Hindu religion is the biggest, and we have got 8 minority religions, in which Christians are 2.5%, Sikhs are 2%, Jains are 1%, Muslims are 12%, and balance about 81 to 82% are Hindus. So that is the minorities of Hindu. So in a nutshell, all our fundamental rights are so guaranteed and enshrined that they provide the minority all their rights which are provided otherwise.
Thank you for that.
Just one common ground too, I think, between the two constitutions and approaches is that both are attempting to rectify historical issues and problems with discrimination.
Yes. I can get you.
I'm sorry.
Yeah,
both constitutions are trying to rectify or to fix past wrongs in terms of how people interact and are treated.
Yeah, if you look at the affirmative action in that sense, though both the constitution ideology is to rectify the historical problems or the oppression of the backward class. The approaches are somewhat different. Whereas in the United States, my little understanding, the quota system is not allowed. So if you are giving an affirmative action, you need to specifically mention whom you are giving favorable and narrowly tailor-made, etc., made. But in India, we had specifically provisions were mentioned in the constitution itself. Therefore, we had a quota system. Like, if 50% of the seats in educational institutions could be reserved for different kinds of backward classes. So we had 3 different classes: scheduled caste, which is based on untouchability; scheduled tribe is based on the way of living in a tribal areas, people; and the third one is the backward classes. The backward class is based on socially and educationally backward people. So all these 3 categories, of course, as she rightly mentioned, to some extent there is a affirmative action for the differently abled persons. Altogether, up to 50% reservations could be provided in education institutions, employment, and it's not stopped there. Affirmative action is also there in political arena where you are contesting the elections for the state legislature. There is a reservation for the people belonging to scheduled caste and scheduled tribe. Even for the federal government elections, we have reservations. We have reservations at the level of counties, that is panchayats and municipalities. And we do also have a reservation based on sex. That is, for the female, we have a reservation of 1/3 seats in educational institutions and some of the jobs. But altogether, it is like a 50%.
That can go up to 49%.
Up to 50% you could maximum. And of course, I don't want to convert into complete a constitutional law class because Martin is very angry for that. So, the approach is different, though the concept is almost similar.
Just give you just a little context about the equal protection concept in U.S. law. It was a response to slavery and the abolition of slavery, and you'll see that the 14th Amendment is what has the words equal protection, and that was passed right after the war that ended the abolished slavery. So that's where it began, and then led to these other things, and then applied to the states.
Okay. And I forgot to mention there is 2 seats in federal government, and each state government is reserved to Anglo-Indian community. Because when the Britishers left India after our independence, so the constitutional framers thought it is necessary for this large Anglo-Indian community residing in India requires representation. So a kind of reservation for them.
Speech.
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 How about the Indian?
No problem, I can't choose because
yeah.
Those Vietnamese.
Our discussion for freedom of speech and expression in the United States, we focused on comparing U.S. and Sudan and Vietnam and India. And we talked about the fact that one specific instance of a difference between the countries would be the burning of the flags. How that would be legal. I mean, that wouldn't be illegal in the United States, although socially unacceptable. It wouldn't be committing an offense, and that's one difference between India and the United States. Also, speaking out against a religion is not illegal in the United States, and it is in India.
Yeah, I would like to.
Is that considered hate speech?
Yeah, hate speech is prohibited in India.
There is one thing I would like to tell you, that the freedom of speech
is existed in Indian constitutions, and it is respected very much because it was mentioned under Article of 19(1)(a), which mentioned that the freedom of speech will be respected by law, and there is nobody can touch for that, even that the governments. But on the other hand, what was mentioned in the Article 19(1)(b), that there is some kinds of the restrictions.
Clause 2.
Clause 2, I'm sorry, Clause 2. That it was mentioned restrictions for using of the freedom of speech itself. If there is any kinds of the using for the freedom of speech to make some kinds of the or to affect of the instability of the society itself, or it could be affect negatively to the national security, then there is no freedom of speech. The persons who try to do that, he will be put under accountability. We can see that there is many cases and many events was happening there. Many people and many groups actually, they use some kinds of actions which could be affected negatively to the national security under the article or under the principle of the freedom of speech. And also, on the other hand, we have to know there is some of the political events, unfortunately, in India that the governments put the freedom of speech or make some kinds of the frozen for freedom of speech under the national security. What happened in the 1971, that there is some kinds of the internal disturbance was happens at that time, in time of the governments of Indira Gandhi. And the government took the decisions that to declare of the emergency. At that time, the freedom of speech was affected, and it was stopped for that. And by this way, there is many kinds of the violence was happened at that times, and the freedom of speech at that time was affected negatively. And many of the politicians actually, they criticize the actions of the
because the reason is under a national emergency. When a national emergency is imposed in India, the freedom of speech could be suspended. So most of the fundamental rights except Article 20 and 21 could be suspended during national emergency. Therefore, if India is engaged in war with a foreign country and if the national emergency was declared, your speech could be restricted.
Yeah.
Constitutionally it is permissible.
Yeah. That is what I would like to say about the Indian constitutions and the freedom of speech under the Indian concept. But what is exist in the Middle East, like in Kuwait, in Jordan, and in Sudan, this principle is exist, but unfortunately, most of time is not that respected because it is not was put as a priority of the principles to be practiced for the people. As we know, most of these countries in the Middle East and some of the African countries, most of the governments was ruled there is military governments. So many of the fundamental rights is not that used very much. So what I can to say, the freedom of speech is not practiced as such in these countries, and by this way, the freedom of speech is not that practiced.
Thank you.
Okay, I'm not going to tell you about Indian or US because I know nothing about that. But I can tell you a little bit about the freedom of speech in Vietnam. Okay, the freedom of speech in Vietnam is a fundamental right, and it stipulates in the Vietnamese constitution. Let's say the freedom of speech like a paper, and you can write everything, you can use the space. But if you go over, your pen will fall down. And I will tell you some reason why your pen can fall down in the case. The first thing is, you know, Vietnam has just only one party. So if you say something, you know, against the party, you will be like the criminal crime. That is the first thing. The second is the media and press company belong to the government. So if you want to say something, you have to have the permission from them. That is the second. And the last one I want to tell you is, you know, actually Vietnamese, they don't use this right much because the character. They don't want to be very famous by telling something. They want to follow the crowd. So it's not happen much in Vietnam. That's all. Thanks.
So basically the difference between India and the US Constitution is, number one, press is not included under freedom of speech and expression in India, whereas the word press specifically mentioned under the United States. Therefore, in India, the press enjoys freedom of speech and expression exactly same as an ordinary citizen in the US. Same, there is no special privilege for the press.
It seems like when I use the word fundamental right, and in the U.S. constitutional system, it's a right a citizen has against government enforcement state action. And it seems like restrictions or punishments for speech against other religions or what's the other example that is flag burning. That falls under a different. There's no state action. I mean, it seems like there's no state action. What exactly?
No. It is a state action because suppose if you
right, exactly. So the crime is the state action.
Like
so
under the Indian Penal Code, incitement and offence is a crime. So therefore, by giving hate speech, you are encouraging the people to commit.
But isn't that private speech? I mean, between two individuals.
It's not two individuals when you openly talk public. When you give a public speech, saying that this particular religion is hopeless or they are bad, you create a hatred. That could be restricted. But the number of cases the Supreme Court has widened and said it doesn't come under hate speech. Very rarely they use. But the government has a policy, means a law which they could stop you from speaking. And when you speak, government could prosecute you, but usually when you go to the court, you get rarely punishment. That means your speech is to a larger extent protective, but if you look at 19 class 2, there are 8 restrictions on the speech. Security of the state, public order, decency and morality, contempt of the court, and integrity and sovereignty of India, maintaining friendly relation with foreign country. So on these grounds, state could impose restrictions on your speech. But when you impose such a restriction, the condition is such a restriction should be reasonable. So 2 grounds. It should fall under any one of the 8 grounds, and it should be reasonable. If either one is not,
it should not be provocative.
If either one is not fulfilled, then the restriction on the speech becomes unconstitutional. And the other problem is, like the United States, they have not mentioned the specific grounds on which your speech could be restricted in the Constitution. So by looking at the US experience, to what extent the speech is going, the Indian constitutional framers wanted to put specific grounds. That's the reason why they kept specific grounds under 19 plus 2. So your speech could be restricted on those grounds.
The country that has the most severe and enforced hate speech laws is Germany. Why do you think that is? Something to think about.
The third group, religion.
Okay. So for freedom of religion, I think a starting point for us was looking at the difference in the language that the 2 constitutions use. The U.S. Constitution in the First Amendment says Congress shall make no law establishing the religion or prohibiting the practice thereof. So it sounds like Congress can't do anything. But for the U.S. students, as we know, the courts, what they'll do is they'll start weighing different factors. And just to speak a little bit about the Indian Constitution, they mention public order and morality, which will be different from how we would speak of it in the U.S. But so for an example of a law that was passed to prohibit a behavior, a religious practice, I'm not as familiar with the case, so hopefully I get this correct. Correct me if I get any of the facts wrong. Jehovah's Witness, they had their children go with them door to door. A law was passed to prohibit that behavior. So the family's argument was that that was part of their religion. And now suddenly the government was prohibiting them from doing